Greetings and welcome back to the Global Business Channel. Thank you for joining us once again today. In this video, we'll be discussing Recommendation 4 of the Financial Action Task Force's 40 recommendations concerning money laundering, confiscation, and provisional measures in Part B of the FATF Recommendation Handbook. Additionally, we'll be reviewing the 17 interpretative notes accompanying Recommendation 4 found on pages 40 to 42 of the FATF Handbook. Every weekend, we publish videos covering topics related to offshore global business, corporate, financial, and compliance sectors. We encourage you to subscribe to the channel and give this video a thumbs up if you find these topics interesting. Without further delay, let's get started with today's video. Recommendation 4 of the Financial Action Task Force pertains to confiscation and provisional measures related to money laundering activities. Countries should ensure that they have policies and operational frameworks prioritizing asset recovery, both domestically and internationally, in alignment with the Vienna Convention, the Palermo Convention, the United Nations Convention Against Corruption, and the Terrorist Financing Convention. Countries should implement measures, including legislative ones, to enable their competent authorities to A. Identify, trace, and evaluate criminal property and property of corresponding value. B. Suspend or withhold consent to a transaction. C. Take any appropriate investigative measures. D. Expeditiously carry out provisional measures such as freezing and seizing to prevent any dealing, transfer, or disposal of criminal property and property of corresponding value. E. Confiscate criminal property and property of corresponding value through conviction-based confiscation. F. Confiscate criminal property through non-conviction-based confiscation. G. Enforce resulting confiscation orders. And H. Ensure effective management of property that is frozen, seized, or confiscated. The essence of Recommendation 4 focuses on the implementation of effective asset confiscation and provisional measures to combat money laundering and terrorist financing. The aim is to deprive criminals of their illicit gains and prevent them from using these proceeds to further illegal activities. The 7 key elements of Recommendation 4 includes: Number 1. Confiscation and provisional measures. Countries should adopt measures that enable the confiscation of property laundered, proceeds from, or instrumentalities used in or intended for use in money laundering or predicate offenses. This includes property that is of equivalent value to the proceeds of crime. Number 2, legal framework. A robust legal framework should be established to support confiscation. This includes laws that define the procedures for identifying, tracing, freezing, or seizing property that is subject to confiscation. Number 3, non-conviction-based confiscation. The recommendation encourages the adoption of non-conviction-based confiscation mechanisms. This means authorities can confiscate assets without a criminal conviction if they can prove that the assets are proceeds of crime. Number 4, provisional measures. Countries should ensure that their legal framework includes provisional measures. These measures allow for the rapid freezing or seizure of assets to prevent the dissipation or transfer of proceeds of crime before confiscation orders can be obtained. Number 5, international cooperation. Effective international cooperation is crucial for the successful implementation of asset recovery measures. Countries should have mechanisms to assist each other in tracing, freezing, and confiscating criminal assets across borders. Number 6, management of frozen or seized assets. Proper management of frozen, seized, or confiscated assets is essential to maintain their value until they are eventually confiscated or returned. Countries should establish effective mechanisms for managing these assets. And finally, number 7, protection of third parties. Measures should be put in place to protect the rights of bona fide third parties. This ensures that individuals or entities who acquire property in good faith and without knowledge of its illicit origin are not unjustly deprived of their property. By adhering to Recommendation 4, countries strengthen their ability to fight financial crime and contribute to the global effort to combat money laundering and terrorist financing. Off to the interpretative notes of this recommendation. Interpretative notes 1 and 2 regarding prioritization and asset recovery frameworks state that countries should periodically evaluate their asset recovery systems to ensure continued effectiveness and allocate adequate resources to support successful asset recovery efforts. In alignment with Recommendation 2, countries should establish robust domestic cooperation and coordination frameworks and agency structures to facilitate the effective implementation of the following measures. Interpretative Note 3 concerning criminal property and property corresponding value stipulates that criminal property and property of equivalent value encompass assets owned or held by third parties, while safeguarding the rights of bona fide third parties. Situations where property owned or held by non-bona fide third parties could be considered criminal property or property of equivalent value include a. Property effectively controlled by the defendant or person under investigation and held or owned by family members, associates, or legal entities and arrangements. Or b. Property that has been gifted or transferred to the third party for a price significantly above or below its market value. Interpretative Note 4 on Provisional Measures argues that countries should empower the Financial Intelligence Unit, or FIU, or other competent authorities to promptly act directly or indirectly upon receiving relevant information to withhold, consent to, or suspend transactions suspected of being linked to money laundering, predicate offenses, or terrorist financing. The maximum duration for such measures should be clearly defined, allowing adequate time to analyze the transaction and for competent authorities to take appropriate actions, such as freezing or seizing the assets. Interpretative Note 5, still on provisional measures, emphasizes that countries should implement measures, including legislative provisions to empower their competent authorities to swiftly execute provisional actions. This should include a. Permitting initial applications to freeze or seize criminal property and property of corresponding value to be made ex parte or without prior notice. Note 6 specifies that ex parte proceedings may include appropriate safeguards under domestic law, such as triggering a notice or an inter partes review following the implementation of the provisional measure, and b. ensuring that provisional measures do not have unreasonable or overly restrictive conditions for effective action, such as the requirement to demonstrate the risk of asset dissipation. Interpretative Note 6, still on provisional measures, stipulates that in order to ensure swift action, countries should empower competent authorities to freeze and seize criminal property and property of corresponding value without a court order, subject to judicial review within a specified time frame. If freezing or seizing without a court order conflicts with fundamental principles of domestic law, an alternative mechanism should be employed, provided it allows for competent authorities to systematically and promptly prevent the dissipation of criminal property and property of corresponding value. Interpretative Note 7, still on provisional measures, emphasizes that nations ought to possess mechanisms, including legislative provisions, empowering their competent authorities to undertake actions preventing or annulling actions that jeopardize the nation's capacity to freeze, seize, or confiscate criminal assets and assets of equivalent worth. Interpretative Note 8 on confiscation states that countries require a broad array of measures, including legislative actions to confiscate criminal property and assets of equivalent value, as outlined in paragraphs 9 to 13 below. The specific measures of combination or measures applied will depend on the case's circumstances. Additionally, it is crucial that these measures are implemented in a way that respects the substantive and procedural rights and safeguards that may be affected by the confiscation process. Interpretative Note 9, still on confiscation, argues that countries should implement measures, including legislative actions, to facilitate the confiscation of criminal property and assets of equivalent value following a person's conviction. Interpretative Note 10, still on confiscation, stipulates that to the extent that it aligns with the fundamental principles of domestic law, countries should implement measures, including legislative actions, that allow the confiscation of other property belonging to a person convicted of money laundering predicate offenses, as outlined in Note 7, where countries may limit extended confiscation to serious offenses consistent with Recommendation 3, or terrorist financing. This applies when the court is convinced that such property is derived from criminal activity, as described in Note 8, which may involve assessing whether the property's value reflects the proceeds of a criminal lifestyle or is disproportionate to the convicted person's lawful income. Interpretative Notes 11 and 12, still on confiscation, state that countries should establish measures, including legislative actions, that enable the confiscation of criminal property without requiring a criminal conviction, non-conviction based confiscation, in cases involving money laundering predicate offenses, as described in Note 9, where countries may limit such confiscation to serious offenses consistent with Recommendation 3, or terrorism financing, as long as this requirement aligns with the fundamental principles of domestic law. Countries have flexibility in how they implement non-conviction based confiscation. Additionally, countries should consider adopting measures that require the offender to demonstrate the lawful origin of the property subject to confiscation. Interpretative Note 13 on asset recovery and tax authorities argue that countries should empower their competent authorities and tax authorities to cooperate, coordinate, and share information domestically to enhance asset recovery efforts and aid in identifying criminal property. In appropriate cases involving tax liabilities, this cooperation could support the tax authorities in recovering those liabilities. And finally, Interpretative Notes 14, 15, 16, and 17 on asset management, return, and disposal state that 14 countries should have effective mechanisms for managing, preserving, and, when necessary, disposing of frozen, seized, or confiscated property. Preserving the value of property should include the pre-confiscation sale of property where appropriate. 15 countries should consider establishing an asset recovery fund where all or a portion of confiscated property will be deposited for law enforcement, health, education, or other suitable purposes. 16. Countries should ensure they have measures to enforce confiscation orders and realize the property or value subject to these orders, resulting in a permanent deprivation of the property or value in question. And 17. Countries should have mechanisms to return confiscated property to its legitimate prior owners or use it to compensate crime victims. That's it, folks, for today's video on Recommendation 4 issued by the Financial Action Task Force. Thank you for sticking around until the end. Your support means a lot to us, and we hope you found the information, insights, and key points valuable. We'll continue to share informative content every weekend, so do not hesitate to return to the Global Business channel for insightful videos on the offshore, global, compliance, and financial services sectors. Take care, stay safe, and we'll catch you in the next one. Cheers, guys.